Construction defects can be a nightmare for South Florida homeowners, leading to costly repairs and potential safety hazards. Whether it's a structural issue, water intrusion, or faulty materials, understanding your rights when it comes to construction defect claims is crucial to protecting your investment. Under Florida law, homeowners have the right to file a claim for construction defects within a specific time frame known as the statute of limitations. Generally, this period is 4 years from when the defect was discovered or should have been discovered. However, in cases where defects are hidden or take time to surface, homeowners may have up to 10 years from the completion of the project to file a claim under the Statute of Repose. Before pursuing legal action, Florida law requires homeowners to follow a pre-suit notice process under Chapter 558. This means that homeowners must notify the contractor, developer, or other personal parties of the defect and give them an opportunity to inspect and repair the issue. This step can often resolve disputes without going to court. It's also important to gather documentation of the defect, including photos, inspection reports, repair estimates, and videos. These records will strengthen your claim if the contractor refuses to fix the problem or offers an inadequate solution. In some cases, the construction company's insurance may cover repairs, so it's crucial to understand your policy and any warranties included in your contract. Hiring a lawyer experienced in construction law can help guide homeowners through the complexities of defect claims and ensure they receive fair compensation for any damages. By acting quickly and following the legal steps, South Florida homeowners can protect their property and hold contractors accountable for poor workmanship.